Hi, Tony.
Hello, how are you doing?
Good. First and foremost, thank you for your contribution to our book, The Law and Business of Litigation Finance. So straight in with the questions. So you're a professor at Cardozo School of Law in New York City. When I was in law school in the 90s, litigation finance appeared nowhere on the curriculum. Is that changing?
Well, it's slowly entering the curriculum. I think that it's clearly always been in the background of professional responsibility courses and legal ethics, and now there are actually some specialty courses being offered. Professor Maya Steinitz, when she was visiting Harvard Law School, offered a course. I'm actually talking to NYU about offering a course, and I think the concern that a lot of faculties have is this really legal ethics, or is it something else? Is it more about the business of law, or even something closer to the area of, say, securities? And they don't really know how to place the course or to categorize it. But there is a lot of interest in the subject, either from the perspective of disciplinary issues for lawyers or from capital markets.
Yeah, and maybe when they read the book, they'll see that it's all of those things that you just described.
Yeah.
And so you've contributed two important sections to the book. The first, in liaison with Professor Capper of Queen's University in Belfast, is about a history of third-party litigation funding in the common law. When I first started moving into litigation funding, people were very excited about these historic legal concepts of maintenance, champerty, and barratry. Why was there such an obsession with these principles, and does it have any relevance to the modern world of litigation finance?
Well, to take your last question first, it absolutely has relevance. And the reason why is that despite the sort of changes in technical doctrine, and there have been major changes in the last 200, 400 years, the underlying response, and this I really have to sort of give credit to another scholar in this area, Professor Brad Wendell, who really described it as the ick factor. There is just a way in which ever since the time of the Christian sort of faith being concerned about the commodification of human conflict. I mean, that was a sort of central reason why the church didn't like people funding lawsuits, and there was a strong prejudice against it in Europe before the 19th century. But that continues today. I mean, it doesn't have to be based on a religious value. People just don't like the idea that strangers make money off of other people's conflicts, and I can completely understand that. On the other hand, I can also understand why, when it's your conflict, you really would like to be able to get the redress that you deserve. And if someone else can help you, as Bentham said, if someone else can help you and profit at it, what's wrong with that?
Absolutely. And when it provides access to justice, that's a very important business pursuit to have. And so your second contribution to the book is in liaison with Lucy Pert. Lucy is a partner in the London office of international firm Hausfeld. And together you examine the professional responsibilities of lawyers in the context of introducing their clients to third-party litigation funding. One of the issues that you discuss I find quite interesting relates to fee sharing. I'm interested, could you describe what fee splitting issues are, and on which side of the Atlantic do you think they're most concerning or a most hot topic?
Yeah, this is a particularly American obsession, and it's kind of funny given that Americans have a reputation of being so pro-free markets. But with regard to this one area of professional life, Americans, more so than certainly the British or Europeans, think that anything having to do with, again, commerce corrupts in some absolute way the purity of the professional value of lawyers. And there's almost a kind of crazy fetish value associated with the idea that lawyers are innocent of commercial interests in the United States. Nobody really believes that, but it's a kind of myth that we have to tell ourselves, I think. And so in the United States, what fee splitting is whenever a non-lawyer profits from the professional activities of a lawyer, whether it be by employing a lawyer in a corporation for services to anyone other than the corporation, or it be a partnership with a lawyer, with a non-lawyer, or even if it be a kind of ad hoc deal where a non-lawyer buys a interest in fees not yet earned as a kind of venture capitalist.
Well, Tony, your contributions to the book have been fascinating. I enjoyed reading them, and I'm looking forward to seeing them on the shelves soon. So thank you.
Thank you very much.